Hello students, welcome to my channel. I think after 2-3 weeks here I am back on my channel. I hope you all are fine. Today we'll discuss the topic from the administrative law. The very first topic, that is nature, scope and definition of administrative law and the reasons for the growth and development of administrative law. Now administrative law is basically the development of 20th century. But it doesn't mean that there was no administration in ancient philosophy. Now if we take the example of India itself, from the Maurya or Gupta period, we could understand that there was an element of good administration in those ancient philosophies or in those ancient era also. But the thing is that Western philosophies or Western countries, the way they recognize the administrative law, the India lacks in recognition of administrative law in those ancient eras. And because of that, now we are taking the reference of Western countries in understanding or in defining the concept of administrative law. Now in this, when we see that the administrative law is the development of 20th century, we have to take into account that at the very beginning, administrative law was considered as a part and parcel of constitutional law itself. But later on, with the rapid development of the concept of state with the welfare state era, we started to recognize the administrative law as a very separate subject for the study. And so now at this juncture or in this current era, we are treating the administrative law as a very fit subject for the study. Now when we see the definitions of administrative law, there are few authors which define the administrative law, and we have to see that the definitions of those authors. In this, the very first, that is the Ivor Jennings. According to Ivor Jennings, the concept of administrative law, what he defined is that the administrative law is the law relating to administration. It determines the organization, powers and duties of the administrative authorities. Now this definition is known as the widely accepted definition. But in this definition also, there is a lack of remedial mechanism. And so in this, the very mechanism when the rights of the private citizens got violated by the administrative authority or the agencies, then how to remedy those rights, that mechanism is not provided in this definition. But still, this definition is widely accepted definition which is given by Ivor Jennings. Next definition, which is given by K.C. Davis. Now according to K.C. Davis, administrative law is the law concerning the powers and procedures of administrative agencies, including especially the law governing judicial review of administrative action. Now this definition is also known as a proper definition of administrative law. It emphasizes basically the procedure which to be followed by the administrative agencies. But in this, it lacks the substantive law, or it doesn't emphasize on the concept of some substantive law which is basically made by these administrative authorities. There is a very point which needs to be noted, that is judicial review of administrative action. And in the US legal system, we understand that judicial review of administrative action is the basic feature of the US legal system. And in this definition, the definition emphasizes on the judicial review of administrative action. And so with this judicial review, we try to control the actions inactions of administrative authorities or administrative agencies if they violate the very rights, fundamental rights of the private citizens or the common man in the system itself. Now, apart from this, there are other authors also which define the administrative law in their own manner, and in that the definition of Jain and Jain, which we can say as an Indian approach to see the administrative law. We say that administrative law deals with the structure, powers and functions of the organs of the administration, the limits of their powers, the methods and procedures followed by them in exercising their powers and functions, the methods by which their powers are controlled, including the legal remedies available to a person against them when his rights are infringed by their operation. Now, administrative law, according to this definition, deals with the four aspects. Firstly, it deals with the composition and powers of administrative authority. Secondly, it deals with the limits of the powers of those authority. Thirdly, it prescribes the procedure to be followed by these authorities in exercising such powers. And fourthly, it controls these administrative authorities through judicial and other organs. Now, this is actually not the definition, but we can say this is a description of the concept of administrative law, which is given by Jain and Jain while defining the administrative law. And so it covers all the aspects which deals with the administrative authority or the administrative agencies. So the powers and functions of the administrative authorities, the structure or composition of these authorities, the limitation on the powers and functions of the administrative authorities, and when they exercise that powers and functions, while exercising, if they violates any rights of the common citizen, then how to rectify that violation or what remedies should be provided against that violation. So all the aspects cover in this definition of Jain and Jain when we see the definition of this particular administrative law according to Jain and Jain. Now, when we see that all these definitions, we have to understand even the nature and scope of administrative law also. So administrative law deals with the powers of the administrative authorities and the manner in which those powers they must be exercised. And so when we see that the administrative law, it is not the only administrative authorities we have to take into account, but when the administrative authority they are exercising their powers, they supposed to exercise their powers within the legal bounds which is demarcated as per the law. And when they are exercising their powers, the very application of their powers, operation of their powers, and along with that application or operation, in what manner they should discharge or deliver that function under the law or as per the law, that can be the part and parcel to determine by the administrative law itself. And along with that, in exercising their powers or in performing their functions, if that functions or power resulted in violations of any individual's right, then the mechanism of that rectification of that violation, that also becomes the parts and parcel of this particular concept of administrative law. And so from these definition, in nutshell, we can determine the very nature and scope of administrative law in today's era. Now, the very aspect of reasons for the growth and development of administrative law, that we need to understand. Now, administrative law, why it developed in 20th century? So many nations, they becomes liberalized after second or independent after Second World War. And after their independence, so many nations, as we said, the civilized nations, they adopted the written constitution. They have that particular element of democracy, and because of that thing, they shape the nation or their system in a manner that they have taken the responsibility for their citizens. And so the first reason for the growth and development of administrative law, that we understand the changing role of the state. And in this we have to understand the state develop in three phases. First, that is a police state, second, that is a laissez-faire, and third, that is a welfare state. And now we are saying it as a social welfare state. In the first phase, state undertakes the only responsibility of maintenance of law and order. In the second phase, state, which is known as a laissez-faire, which means it is nothing but the minimum governmental control and maximum enterprise. So it opens the commercial transaction for all. But when this laissez-faire resulted into inequities in the society, because bargaining capacity of each and every individual differ from each other, and so laissez-faire resulted into unequal society. So at one hand there is a very rich class which develop, and at the other hand the very poor class is developed, and so the society becomes imbalancing society in the laissez-faire era. And so to overcome from this particular phase, state adopted the concept of welfare state. And in this welfare state, state undertakes all the responsibilities for its citizen. And so citizens, they are taken care, or they should be taken care by the state itself. State is a protector, state is an arbitrator, state is an entrepreneur. All these are the roles of state which is adopted in this welfare state era. State takes care of all the issues, all the responsibilities for the citizens from cradle to grave. And because of this change of the role of the state, there is an expansion of transportation, banking institutes, finances, insurance companies. And because of all these expansion of multifaceted functions of the state, that resulted into the growth and development of administrative law. The next, which is nothing but the judicial adjudicatory functions of the state. Traditionally, the courts, when we see, they have to undertake the adjudication of all the matters, and because of this, judiciary is basically the overburdened judiciary. And to see this judicial system, there is a need to be some different mechanism, because delayed justice is known as a justice denial. And so traditional judicial system, when becomes inadequate to dispose of the matters in a speedy manner, there is a need of somewhat a different mechanism which can deal with the matters in a speedy manner without any particular expensive measures. And so the concept of tribunals, which is a byproduct of the concept of administrative law, taken place, and we can see that without any rigid formal approach, these tribunals, they started to settle, or they started to adjudicate the dispute between the parties, and that also resulted in the growth and development of administrative law. In the same manner, the third reason we find that the legislature is also overburdened legislature, because when we see the legislature, there is also the formalistic approach to enact laws, and that formalistic approach also becomes a hurdle in the demands or legislative demands of the people. And so to overcome from that particular hurdle, there is a need of such particular administrative agencies or the executive agencies which can unmake the laws, which is a very necessary for the common people, and that can be done through administrative agencies. Moreover, when we see the legislative function of the parliament, so many technical issues which can't be handled sufficiently by the legislative members of the parliament, but that can be sufficiently handled, treated and resolved by the administrative experts, knowledgeable experts. And for that reason, the administrative agencies, they undertakes the actual lawmaking function of the parliament, and through them so many such rules, regulation, that becomes the order of the day, and so even that also contributes in the development of administrative law. Now next, the experimentation is possible with the help of the administrative agencies. And so while lawmaking, if there is a need of a particular rule which can be tested, if it is work out, then it can be implemented in a full-fledged manner. If it doesn't work out, then it can be immediately withdraws, or it can be modified, it can be altered. And so with the formal approach of the routine parliament or the legislature, such experimentation is not possible. And so there is a need of the administrative agencies which can be immediately make that particular rule, which can be test that particular rule, and if it is not working properly, they can immediately roll back or withdraw that particular rule. So such modification, alteration in the rule making with the help of administrative agency, we can perform properly and immediately, but which cannot be performed with the routine legislative function in the system. And so that is also one of the reason for the growth and development of this particular administrative law. Now next, that is administrative authority can take the preventive measures. And so while prevention is the better than the cure, what we understand, and so while issuing the licenses or while issuing the rate fixing functions, performing the rate fixing functions, we can see that the administrative authority can adopt the preventive measures. Further, administrative authority can take the effective measures for the enforcement of these preventive measures. And so when we see that the preventive measures, in these preventive measures, they can do, or they do not have to wait for the parties to come before the dispute. So in the preventive measures, they can immediately declare what the stakeholders they should do and what they should not to do, and on that basis, if the concerned person has overruled the mandate of that administrative authority, they can take the immediate action. And so when prescribing the preventive measures, administrative authority can see that how to enforce that preventive measures. And so suspension of license or cancellation of license, these are the very functions which can be immediately performed with the help of administrative authority to enforce that particular preventive measures. So these are the basic reasons, we can say, which leads to the growth and development of administrative law. And so it is nothing but, when we determine the three organs of the government, that is legislature, judiciary and executive, administrative law is nothing but an excuse from the routine, rigid, formal functioning of the legislature, judiciary and executive, because these are the authorities which having the functions, powers, which is a less formalistic and which is not a rigid as we understand in the lawmaking function of the parliament, or as we understand in the formal approach of the judiciary when they are determining a particular matter. And because of all these reasons, administrative authority is become the very necessary evil in today's era, because they are giving option, they are giving alternative to traditional judicial function also, they are giving alternative to the rigid legislative function of the parliament also. So at the hands of the administrative authority, the rules, regulations can be made very speedily without wasting much more time, and at the same time, with the help of administrative authorities, the adjudicatory functions of the traditional judicial system, that also can be effectively, speedily performed in the system. And because of these reasons, there is a popularity to the concept of administrative law, and these are the basic reasons we need to understand in the growth and development of administrative law. So in short, I sum up this particular thing in the administrative law. I hope you understand this video and it will help you in your study. Thank you very much for watching this video. Thank you.